Council members here focus on a single topic of relevance or items of timely importance.
Pleased to have our guest from the state with us today. And Barbara, why don't we start with you as the Executive Director for the Department of Revenue. Bring us up to date, where the state is, where is it going, what are the plans? And I know we're going to have some questions for my colleagues. But why don't we give you first crack and go ahead and get started. And again, thank you for coming.
You're welcome. Is this on? Okay. Thank you for allowing us to come and talk with you. As you see at the table, you have the Executive Director for the Department of Revenue, you have the Senior Director for the Enforcement Division, and you have the Director for the the Marijuana Enforcement Division now. And so, as you can tell, we have a great deal of interest in making sure that we implement the regulation and the enforcement requirements of Amendment 64 appropriately. I'm not sure how much of the background that you know, but we did have a task force that was set up by the governor in December. That task force was charged with identifying recommendations, addressing issues and identifying recommendations, and providing a report out to the governor, the General Assembly, and to the Attorney General. We did that work through, I was one of the co-chairs along with Jack Finlaw, who is the governor's chief legal counsel. We did that work through not only the task force but also working groups, and we were very appreciative that you had 2 members of this city council that were on one of our working groups and helped us tremendously. So with that in mind, I think a lot of your input, thankfully, has already been given to us, and we appreciated all of the work that they did. At the end of February, the task force concluded, and then by the middle of March, we issued our report. Right after that, the General Assembly convened a joint select committee that was both bipartisan and contained members of both chambers of the General Assembly to address the recommendations, identify which ones needed to be as part of legislation, and how to move forward on that. That went through the end, literally, of the legislative session, and it was actually on the last day of session that we were able to get all the final votes and get that legislation approved through the General Assembly. Actually there's about 4 or 5 different bills that were signed by the governor on May 28th, and they address the regulatory environment, they address the tax bill that will be going out to the voters. They addressed some other issues with regard to education and additional information to the public, to educators, to the medical profession, as well as DUID. That was also passed, but also some other things that had to do with how we manage our licensing in connection with the local jurisdictions. One of those bills also addressed kind of a decoupling between the state and the local, but allowed for conditional licensing. So with that, we are now moving forward on emergency rulemaking. We have, I think, passed this out to all of you. This is what we put out on our website on Friday to address how the rulemaking will be proceeding. Because of the time frame that we have and the rigorous debates that went on from December through just last week, we know that we believe that we have received a lot of information from the public and from the other interested parties. But basically, with the result of the short time frame within which we are absolutely required by the amendment to have rules in place July 1, we thank you. We will be moving forward on the emergency rulemaking. We will have, at this point, not be taking any additional input, but as soon as those are up on the website, which will be on or before July 1, at that point we will begin taking input from all the stakeholders and begin to convene all of the requirements and the hearings with regard to a permanent rulemaking. With that, I think I will open it up for discussion or question, comment.
You want to address the time schedule?
Yes.
That you're under?
Yes, and the time schedule that we're under is really addressed and dictated by the amendment. The amendment essentially lays out kind of a two-pronged method of licensing. The state has to act within 90 days of application, or if it does not act within 90 days of application, then that particular applicant can then apply to the local jurisdiction to receive their license from the local jurisdiction and not the state. The reason that's important, and I bring that up first, is because that connotation drives everything else and the criticality of everything else. The other thing that was in the amendment was that by July 1, the Department of Revenue was to promulgate rules with regard to licensing, application requirements, and a number of other things. As of October 1, the department is required to begin to take applications. By October 1 as well, the local jurisdictions can put in place any additional requirements that they might have as well. By January 1, 2014, the department must begin to issue licenses for those applications that it received on October 1. With regard to that, that is why it's critical that we have in place the rules on July 1, because the implication in the amendment, it's not really an implication, it's actually a statement, that if the department does not have rules in place on July 1, then we will forego the ability to regulate this industry.
Wow. So it's not a question of if, but you will meet the deadline.
Oh, we absolutely will.
Good. Councilmember Nevitt had a question.
Thank you, Mr. Chair. How are you, Barbara? Nice to see you.
Thanks.
So, with respect to the July 1 rulemaking, I mean, it's emergency rulemaking, does that cover the entire scope of, I mean, I understand they're temporary and emergency, but does that cover the entire scope of the issues around which rules need to be promulgated? And the reason I'm asking that question is, you know, further down on our agenda, we'll be reviewing our first draft of regulating ordinance for the city and county, and I think, well, we'll see how it goes, but I think for the most part, our philosophy is if state rules cover it, we're good. If the state's going to take care of it and regulate it, we're good. We don't need to complicate our own ordinance, but all of that is with the proviso that what the state is doing meets our needs. And so I want to have a sense of what we'll know what the state is doing on July 1st as we move forward with ours versus what we won't know. We can always come back and amend it. We've done that before with medical marijuana, but just having a sense of what we'll have a firm grip on with respect to what the state's doing by July 1 versus what we won't.
Well, let me give you some general, and then if we need some specifics, we can move into that. But if you recall, Section 5 of the amendment listed out the requirements of the department for promulgation of rules by July 1. And in there, it addressed the procedures for issuance, renewal, suspension, and revocation of a license. It addressed the schedule of application, licensing, and renewal fees. It also addressed qualifications for licensures, so qualifications for the licensees who wish to enter into this business, right, who's eligible. Security requirements for marijuana establishments, requirements to prevent the sale or diversion of marijuana and marijuana products to persons under the age of 21, labeling requirements, health and safety regulations, and for manufacture and cultivation, restrictions on advertising and display of the products, civil penalties for failure to comply, and also an accountable system. So in essence, what that will be the bulk of it, but those are the high-level categories. Those were then more fully fleshed out in the legislative process. So we have additional requirements there, but suffice it to say that those are the things that we will be putting in place as of July 1.
Great, thank you.
Any other questions before I start asking some more? Ron,
Yes, sir.
how long have you been director?
I've been the Senior Director of Enforcement since October. Prior to that, I was the Director of the Colorado Division of Gaming for about 7.5 years. I've been with the Department of Revenue for over 21 years.
Ron, you know there was an audit, and it came out this spring, and frankly and candidly, I thought it was an embarrassment to the state. The number of posts in his Sunday editorial termed the audit as scathing, and that the Enforcement Division had done an awful job, an abysmal job, in fact, it said, of regulating medical marijuana pot dispensaries. Would you tell us what happened, why did it happen, and how can we be sure, and this is the most important question, that this industry indeed will be regulated from seed to sale as we were promised?
Before you start, can I just,
Sure,
let me just start. First off, Ron and I have both testified on this issue before the Audit Committee, the Joint Select Committee, and then the Finance Committee of the House. And so the first thing I want to say is that we have addressed this issue in front of the General Assembly multiple times, and we are comfortable, and we believe that we have made them comfortable with the fact that we all stand ready and have stood ready to address this issue and to move forward on this industry and with this division. I will tell you what I said to each one of those audit committees, and that is, regardless of when these issues occurred, I am responsible, and I take responsibility for the department and the department's actions, even for the things that occurred before the three of us were in these positions. So, having said that, that's not really an excuse, but that is an explanation. And what we did is I came in July of 2011, after much of what you saw in the audit. Immediately, I began to look at that division as well as others to obtain facts and data and figure out where we were with not only that division but others. Very quickly, in November of 2011, I asked Laura Harris to take on that division's responsibilities. I asked her to look at it with new eyes. I asked her to challenge all of the assumptions that had been made. And what I will tell you is that she did that, and she did that very well. What we discovered, what the audit uncovered, were things that we had already discovered. Let me put it that way. And we had already put in place things to address all of the issues. We had put in place a controller over that organization. We had removed a lot of the state cars that had been leased into that division prior to that. In addition, we had also begun to really look at the revenue projections, because the revenue projections were a little too optimistic. And so we looked at the revenue projections. We started to discover that we were not going to be able to meet the revenue projections that were originally discussed and thought to be the case. We also looked at all of the expenses, and we started to cut back on all of the expenses. And what we ended up doing was we had an appropriation for 55 individuals to do that work for the medical marijuana division. At our peak, we had 37 employees, and at the end, we ended up with 15. So we had 15 employees trying to do the work of 55. So, and how that came to be was as a direct result of the funding mechanism that had been put in place. There were two things that were a big issue. Number one, the funds that went into that, the dollars that went into that fund were really two things. They were the application fees and they were the annual licensing fees. The original team believed that as this industry rolled out, that it would not be quite as volatile as it was. But it was volatile. We had for a number of reasons. Number one, the fees themselves were not sufficient to support the entire industry and all of the regulation and enforcement that needed to happen, number one. Number two, we had our licensing structure tied to local approval as well. And as a result, once the state had concluded all of its work, we couldn't actually license until the local jurisdiction had actually licensed on its side as well. Once that happened, then we could issue the license, and then the annual licensing fee began to kick in. But until then, we didn't have an annual funding mechanism to address this. So as a result, although we had an appropriation, $5.7 million, the funding never reached anywhere near half of that, and as a result, we were unable to sustain a predictable funding stream, a predictable full-time equivalent stream, or the enforcement and regulatory oversight that was absolutely necessary. What we've done is a number of things. With that in mind, we have done two things. We made sure that as we were moving through this task force and the legislative process that we asked for predictable funding. Number one. Number two, the second thing we did was we also asked for what we call a decoupling of the state license with a local license so that we can move forward on a conditional license pending the locals doing their portion of it, but we can at least begin to assess and receive the annual licensing fee irrespective of the length of time that the locals will take to do the work that they need to do.
The state invested $1.1 million in an inventory tracking scheme, and that goes back to that seed to sell system that we were promised. We still have that, I presume.
What we have done is we are working right now with the vendor because there was a portion of this that was not completed because of the funding shortfall. We have the funds available to us now. We've worked with that vendor. We are very close to rolling that out. We will be rolling it out not only for the medical marijuana portion of it, but there are additional requirements that we have of this vendor for the adult use portion, because we now need to be able to address and to track whether excise tax has been levied and paid in the event all of this comes through. But we need to keep those separate. So as a result, we are in the process of getting that rolled out. We will be very soon rolling out the medical marijuana portion of it and then augmenting it with the additional requirements for the adult use.
But I'm not quite clear. What have we done with the $1.1 million system that we bought?
Well, do you want to go ahead and take this one?
Sure. Councilman, the contract award for this company was for $1.4 million. At the point when we discovered that we were essentially running out of money because we didn't have the cash flow, that contract, along with a lot of other contracts that were ongoing, were put on hold. So that $1 million that has been expended, that product is still there. What we've done is we have begun to restart that project so that we can finish it. So that once they finish that inventory system will be launched. It will be available for us to use to track all the way from the small plant, all the way through the sale of the product.
So, Ron, this is the same Florida company.
Mm-hmm.
That's correct.
So we're not losing
No.
That's
our
correct.
initial investment. That's all. I just
That's
wanted
correct.
to give you an opportunity to clarify that.
That's correct, and that was very important to us that we not lose that money that we had already expended and invested into this system, and so they've again we've restarted the contract. We've begun meetings with them, and we'll be working with them very diligently here to make sure that we get the program up and running. There'll be some training for the industry. We're also, because some people in the industry have different systems to track their marijuana inventory, so we need to make sure that it will communicate with our centralized system.
Any questions? Come on. Yes. Yeah.
Thanks, Mr. Chair. Barbara, thank you for coming. Can I ask, you were all in the process of updating the medical rules, right, as some of the amendment passed and the recreational adventures began. So are you still updating those? Is that update done? I guess I'm just trying to understand from an industry perspective as well as a department perspective. Are both courses changing at the same time, or is one going to be done and then the other beginning?
I think I'll have Laura Harris take that.
We are actually, our hope is to do a simultaneous adjustment to the medical rules to align them with the adult use. So there is parity between the two.
Got it.
But of course, we don't have the same statutory deadline for the medical. So, if there is not enough time to do both projects, our initial, our primary obligation is to deliver the adult use rules by July 1st. But when we go into our permanent rulemaking and we start to have stakeholder groups, if the medical is not done by then that will be close behind. So our effort is to make it more efficient by bringing both sets of rules together.
Great. And one follow-up, Mr. Chair. So the hope is there might be a short window during the emergency rule time that someone who's in transitioning might deal with conflicting or differing rules on the medical side and the new adult use side. But by the time those become permanent, in theory, and where I'm going is one of the discussions we're going to have is, are we comfortable, I think, with having a joint facility that provides both medical and recreational? And I guess where I'm going with my question is just understanding whether or not there will be kind of conflicting rules that foreclose that or make that, you know what I'm saying? Like, will a business be able to comply with both at the same time? And it sounds like the goal is by the time the rules are permanent. What's the delay between when they're emergency rules and when the permanent rules would take effect, in theory?
Well, based upon our, the rules become effective on July 1st. Based on our announcement, we're going to have the hearing on or about August 22nd. Okay, they'll be promulgated sometime toward the, actually they're effective more along the lines of October of this year. Okay, so the emergency rules will become permanent at that time if they're not amendments. So the time frame between the adoption of the emergency rules and the adoption of the permanent rules are the stakeholder groups, and based on the stakeholder input, will amend the emergency rules and permanently adopt them in October. Okay, so our hope is to, is that not correct? Okay, the permanent rules will be adopted in October. And our hope is to bring the medical rules along in that timeline so that there's, again, parity between the two sets of regulation. For example, our plan is to have the same security requirement for both. Right. Requirements for video surveillance are going to be the same. So there's no need for licensees to study a rule for if they're retail versus whether they're medical. It's going to read the same.
Right.
That answers my question.
Councilmember Robb.
Thank you, Mr. Chair. I think my question is for Laura Harris. Hello. And I'm just curious. I know that Tom Downey in our Department of Excise and License tracks our local licenses. Do you know how many medical marijuana licenses, off the top of your head, we have in the state of Colorado right now?
Well, we've finished, I think it's about 1,000 total.
And you have more pending applications?
Yes, we still have about 300 pending, a little bit above that, of which, based on House Bill 1238, we have about 82 in the city and county of Denver that we're ready to issue now that we are decoupled from requiring local verification from the city and county of Denver. So there are 82 applications we're able to, with little or no updating, to go ahead and issue.
So now that I asked that question, I have a follow-up. Of the 82, now that you're decoupled, did the state legislature decouple the medical marijuana licensing as well as the recreational, or are those 82 for recreational licenses?
I'm sorry, those 82 are for medical.
That makes sense, since we don't have the rules in place for the
Right,
others.
House Bill 1238 was associated with medical marijuana only.
Okay. Okay, and so what is the annual licensing fee?
It depends on the license that we're talking about. It
Okay,
could
for a
range-
center, medical marijuana center right now.
Oh, I don't have, you have that.
And and was that set by the state?
Yes, it was set by the state.
Okay, and you are collecting those at this point?
Yes, we are.
Okay. When you get the fee, I'd be interested.
For those that are licensed, we're
Right.
For those that are licensed, we are continuing to assess the annual licensing fee.
I apologize, we didn't come with our fee schedule today.
Well, that's okay. You've got 82 more to look at in Denver that are medical marijuana. And since we're looking at sort of transitioning our medical marijuana facilities, that adds to that number. Do you know, and I know Tom Downing tracks it, but do you know how many are licensed in Denver?
No, I can't give you that figure today.
All righty. We can get it here. Thank you.
Can I just clarify one thing?
Sure.
Because I think it's something that was kind of a surprise to many people as we walked through this. But when the legislation occurred in 2010, the legislation itself that kind of defined how the cultivations, the marijuana-infused products manufacturers, and how the medical marijuana centers were going to be licensed, it recognized that there were a number of businesses that were already in place. And so what it did is it grandfathered in those businesses. And so that's where the difficulty has come in, is those businesses have been operating but weren't fully licensed between the state and the locals at that point. And so there was, if you think about that, there was the expenditure of the regulatory environment without the input of the annual licensing fee. And so that is where the disconnect in funding also occurred.
So if I could just clarify, when you say you have 82 more licenses, they may be licensed locally at this time point? No? Okay. I just want to be clear.
Mary Beth? Councilmember President Sessom.
Oh, thank you, Mr. Chair. I'd like, sort of keeping on the financial side of that, the tax-related rules, of course, there's, the state's going to do a 15% that the amendment allowed, and then another 10%, and then I assume you're going to keep is it the 2.6% state sales tax, or are there, it's sort of related, this tax-related dealing will be dealt with under a separate rulemaking process. Do you expect there will be an additional sales tax that you will be adding? And when is this rulemaking going to happen? Probably in time for the ballot, I suspect.
Councilwoman, thank you. There is the regular sales tax, at the state level, that's a 2.9. At each of the municipalities, it may be something in addition to that, but that is the regular, what I call the regular sales tax that applies to all tangible personal products. Okay, so that will continue to be assessed on both medical marijuana, and that will be assessed as of July 1 on any of the adult use or the retail marijuana as well, or marijuana products. Now, what the additional tax that is subject to voter approval was the referendum was approved through House Bill 1318, and that will be an up to 10% sales tax, additional sales tax, and an up to 15% excise tax. That 15% excise tax can be lowered by the General Assembly on an annual basis later on if they deem that necessary. My understanding is it's supposed to be going towards capital construction for schools, where the additional 10% would be used for education, for the social, the attendant social costs that are as a result of this industry, and so education, studies, those kinds of things.
And then you would use the 2.9% for enforcement?
Yes, what House Bill 1317 did was establish that the funding mechanisms, I want to make sure for enforcement were both the application fees, the annual licensing fees, the sales tax, the regular sales tax for medical marijuana, and the regular sales tax for adult use marijuana. That fund will also, once the election occurs, and if the election is successful, then that's where the excise tax and other sales tax will go in. But that money is to be appropriated in a different manner that will not be going to the enforcement division.
Tim?
Welcome. I have a couple of questions. So the first one is on the issue of separation, where there potentially could be co-location of a medical and a recreational. Have you all begun to think about whether or not you're going to require separate entrances? I'm assuming separate tracking of their sales and all of that would be expected, but can they operate where people can go in one door and on this side of the room is one business and on this side is another, or does there have to be a very clear separation between the two businesses? Is that something you've taken a look at yet, or is that still something to be done in the rules and regs that are yet to be seen in July?
Well, let's talk about it, and thank you for the question. Let's talk about it by business type. The cultivation facility, which is essentially the grow, through the discussions at the task force as well as in the legislation, it allows for the business owner to actually determine whether they want to do what I call either physical or virtual separation. So if you envision a grow, it's a big warehouse like this, and you have plants that are just kind of walking through the process. If you have a plant on this side that has a blue tag that says it's for medical marijuana, and you have a plant next to it that has a red tag that's for this particular business owner's recreational or adult use marijuana business license, I mean, they can continue to go through and each take part of the light that it goes through, because it's easy to keep those separate. So it's
on the retail side that I'm more
the centers and that's what I was going to say, and that's where it gets a little trickier. Now, in the legislation, as I recall, it allows for the municipalities to determine whether or not they're going to allow dual use in the same physical location. With that in mind, I think that the local jurisdictions have a great deal of authority, but it also leaves to the department as well to promulgate rules to look to determine whether or not that will be required. And let me see, because I had that written down here, so I want to make sure I put this correctly. So essentially, it says that the Department of Revenue will promulgate rules to determine whether to allow single entrances and exits, and whether virtual separation of inventory will be allowed. So that's going to be something that as we move forward, we will be taking public testimony and looking at our stakeholder groups, of which the local jurisdictions are that, to determine what makes the most sense and how do we make sure that we protect the public, and especially those individuals that are under 21.
Thank you. I have one other one, and this one is for Tom Downey. And I just want to ask Tom, of the 82 that the state has that are pending, have they already made application to the city of Denver? So do they concurrently apply for their licenses in both the state and the local jurisdiction?
Sure.
Hey, Tom, introduce yourself, please.
Tom Downey with the Department of Excise and Licenses. I'm not sure of which 82 that they're talking about, but there are...
medical.
Right, I'm sorry, but I don't know which category they fall into. So this is an area where we've had a lot of conversations. When I've been asked this question a number of times before, how many centers do we have? I always give the first answer of it's about 205, and then I do a pull aside with whoever asks to explain everything, and I email things to council staff and those kinds of things, because exactly as Barbara had explained, there was this issue of the grandfathering, where folks were in but not necessarily licensed. So what happened was folks went through a screening process at the Medical Marijuana Enforcement Division where they were allowed to apply to us for their center license or their grow license. But they weren't actually licensed once they got that screening, but under the state statute that grandfathered them, they were allowed to continue operating. So we have three categories. We have those that went through the MMED screening, came to us, applied, we processed them, and then sent that application over to the state. And then they are fully licensed, and we have those. Then there's a second category, the other extreme, where they went through the screening process, and then they said, wait a minute, why in the world should we go and pay the money for the application over at Excise and Licenses with the city? Because we can already operate. There's no end date to it. We're allowed to operate under the grandfathering, and so they passed the screening process, but they never actually applied to us or to the state. And then there's a third category, which is in between. Those that passed through the MMED screening, exactly as Barbara explained, came to us, applied, we processed them, issued them their inspection card, and then the same thing, they said, well, why should we go through all those hoops? And they've never returned to us with the inspection cards. Now, let me explain that there are some wonderful operators out there that got their inspection cards, and they're in the process of turning those back. But we can't discern between those who are just in the process of complying with those inspection requirements and those that are just sitting on them. So those are the three categories. I don't know where in those the 82 fall, but our numbers are very close. The total is about 205 because we know the number that is already licensed with us plus the number where we've issued inspection cards but they haven't come back, and then we've been working very closely with the MMED on figuring out that number that has gone through the screening but not applied to us.
Okay, Debbie, City Attorney Broadwell had a question. David.
Thank you. David Broadwell, Assistant City Attorney. I just wanted to follow up on Councilman Ortega's first question about co-location to make sure we're clear about this. As Ms. Ball indicated, indeed we had exercised full local option about whether we're going to allow it or not. But I think part of the motivation for the question is to understand whether the rulemaking is going to happen first before we have to make that decision. And it's one of various areas we have kind of a significant chicken and egg problem here. We've identified that as a decision we get to make, but several council members have asked, but what's it going to look like, particularly in the retail store situation? And I just want to confirm what I think I heard a moment ago, which is that as of July 1, 13, we're not going to have a rule on that yet. That's not going to be a part of the first round of rulemaking. To the extent the 1317 mandates that you all promulgate extra clarification and guidance as to what the physical separation may or may not look like, will we know that as of July 1?
You will know that as of July 1 for the emergency rulemaking, because that will be a part of that. Because what we need to be able to do is, if you think about that, there will be businesses out there that will either choose to stay in the medical marijuana space, they will choose to convert completely into an adult use business model, or they may choose to be a hybrid and do both. And in order for them to be able to make their decision, their business decision, so that they can have an application on October 1 to do that, we have to be able to let them know by July 1 what the requirements are going to be and what the puts and takes are going to be. Now, having said that, on July 1, we may find businesses that say, we want it different, and therefore, for the permanent rulemaking, they may be asking for something different than what we put out July 1. And as part of the requirements that we have for permanent rulemaking, we take stakeholder input, and then we make determinations based on that. But that should be something that would be so let me back up and just kind of make that real clear. So as of July 1, yes, you will know what the division has deemed to be the rules in place for the emergency rulemaking. After that point, we will take stakeholder input, but that will be something that will be out, public, transparent, and as a result, you will all can be involved in that. You will know about it, and we will be putting things out on our website as to what those comments are. So, as a result of that, you should be able to know as you move forward in your process what things are happening.
Thanks.
Councilmember Ortega, you finished with your questions?
I had one more, but
Okay.
I'll pass and wait for a second round.
Well, why don't you go ahead? I don't know if
Well,
you're going to have a second round.
So I just wanted to follow up with something that Tom Downing was saying, where he was describing the three categories. And what I understood him to say is that there are some businesses that are operating that were grandfathered but had not come to the city to get their license from the local jurisdiction. So how do we know who they are, how many there are, whether we're collecting taxes? Do we have the wherewithal to even track all of that?
Again, Tom Downey with Excise and Licenses, and it's a terrific question. And you've asked a number of questions within, so let me try and answer them. First of all, yes, your assessment. Thank you, Councilman. It's supposed to go the other way. First, the premise to your first question is yes, correct. There are businesses that were grandfathered in under the state statute and allowed to operate without a license. The idea was that, again, taking a step back, this is a strange industry in that it was created and popped up before there was any regulation.
Right.
Then the city created regulation, licensing structure. Then the state created a licensing structure. Then the city amended its licensing structure under the state licensing structure. So it was a strange system that how this grew. One of the things that happened was when these things started popping up, the good business owners would go and hire good lawyers that would tell them, sorry, there is no license for what you want to do, but we're going to advise you to get the closest thing possible. So if it was a grow facility, they would say, go in and get and I'm going to pronounce this correctly, a plant husbandry license. So that's the license you get if you're growing tomatoes or flowers. And they would say, this is the best we've got right now. And then when the grandfathering came in, when there was this screening process that Ms. Brohl talked about, that's what it was. They needed to show proof that they were in existence before the grandfathering deadline came in. And so they would show their plant husbandry license. They would also show that they had a sales tax license. And then that was proof. When the reference was to the verification forms, that's what we would sign. They would ask us, have they shown, they would say, we have this application in front of us for this screening, and we're now asking you, the local jurisdiction, this one is in Denver, is it valid? Has it been in operation at this address? Do you have proof of it? And then we would look at whatever license they might have had, a permit, whatever it was, sales tax license, and we would say yes. And we'd sign the form and give it to them. Taking a step back, one of the glitches we had when this administration first came in, because there was new regulation that had just started, was, and this was almost comical if it weren't sad, my predecessor had been told that they couldn't, and this was the Attorney General's advice to the MMED, was you can't give the local jurisdiction the full applications until they've signed the verification forms so they can get through the screening process. The city attorney appropriately told my predecessor, you can't sign the verification forms until you review the application forms to actually verify what you are signing as verified. And so we ended up working out a system where literally our office, we picked up, including staff from our team, the city attorney, and we went over and worked out of their office at the state MMED, files remaining under their custody. And that's how we got through that glitch and got to break the first logjam. So that's how we got to where we are now, Councilwoman. We do have a pretty good handle on the sales taxes. As far as we can see, they are paying their sales taxes, with the exception of it's a cash business, so we don't know completely. But that's one of those things that we looked at.
Thank you.
Okay.
Thank you.
Thank you. Barbara, let me ask you a question about staffing. You projected that you needed, I don't know if it was you or someone else, 55 state employees to deal with medical marijuana. What are you projecting now, and what are you projecting as an increase in business?
Well, thank you for the question, Councilman. We are still projecting essentially the same number of employees, and let me explain why. The first year, the first 9 months, there is essentially kind of a grace period, or I'm not going to call it a moratorium, but some sort of a grace period, so that only those businesses that are currently licensed medical marijuana businesses or had an application in as of December 10th, 2012 can apply for the new either a dual use or a regular business license on the adult use marijuana business model. So as a result, for the first 9 months of the year, the only businesses that are going to be applying, so they will apply from October through July of next year, the current businesses will be the only ones that will be applying for the license. After that, there will be other business models, other businesses that will be able to apply for those licenses in the adult space. What that does for us is two things. The other thing that we're going to be doing is we're going to be allowing for a, what is it called, a kind of a letter of interest of some sort that says that they're interested. Notice of intent. Thank you. That businesses can file with us a notice of intent, which says that they intend to file an application for adult use marijuana after the 9-month grace period. So as a result, we believe that we will be able to kind of have a pretty controlled rollout of the adult use marijuana business model for a period of time. And what we will be doing along the way is watching and really keeping track of the growth of the industry so that as needed, we can go back in and request more FTE if necessary. But we believe that at least for that first year, the individuals that we have identified will be sufficient to take care of both of parts of the industry because, as I said, it's really going to be just a migration from one part to the other as opposed to a doubling of the business.
So you're going to start with 55 FTEs?
We're not starting right now with it, but we have a ramp-up plan to get all those employees in place so that we have, how we're planning to do that is to get the employees in place that we need to address the licensing of applications, so to do the background checks, to do all of that. So we'll get those folks in place between now and October 1. And then between October 1 and January 1, we'll put in place the individuals that need to be there in order to start doing the enforcement and regulatory work. So by January 1, we believe we'll be pretty close to being at our peak. And as a result, we'll be able to start moving forward then.
Obviously, no one at this table wants a repeat of what we saw in terms of the state and the audit. I still maintain to this day that if that audit would have been released in October, an October surprise to use political jargon, Amendment 64 would not have passed. That's the impact it had on me and many of my friends and some of my colleagues. It was so devastating. As you look behind you, you can see number 2 on the agenda today is a straw poll. Shall Denver opt in or opt out? And the reason I invited you here today was to assure us that we would not see a repeat of what happened. Can you assure us of that?
No pressure.
You want a drum roll?
Okay, I'm going to read you a couple things.
All right. It's not your resignation letter, I presume.
No, not a bit. What you'll find is I'm a problem solver by nature. That was just a problem. We're solving it. What I will do is I'm just going to read you a couple things of the testimony that I gave before those 3 committees at the state legislature. Good. And so what I will tell you is that it says, I'd like to address those questions concerning and provide some context for the challenges the division has faced, share what we've learned, the changes we've been making, and assure you that we're not only in control of the MMED, but we'll be able to effectively meet our regulatory and enforcement responsibilities for adult use marijuana as well. And as I've said many times, During and since the audit, I take responsibility for my department, and no one is more committed than I am to getting this right. Now, let me tell you what taking responsibility means. Taking responsibility meant coming into the department on July 18th, 2011, and starting to collect facts and data about the divisions. Based on that, I began to look at MMED, and I asked Laura to take over the MMED division. She brings with her more than 25 years in liquor enforcement. She's received criminal investigator training at the Federal Law Enforcement Training Center, and these skills qualified her for this new challenge. I specifically asked her to evaluate all of the operations of the division with a critical eye, and she's done so. In addition, I asked Ron Camarzell to take on the leadership position over the entire enforcement division. He has spent 20 years with the Division of Gaming. He served as an audit manager, senior investigator, agent in charge, and then director. And during that time, he also was a sworn agent of the Colorado Bureau of Investigation on a year-long special assignment to investigate government corruption. He also has a lot of experience in complex criminal and financial investigations. He's post-certified, and he's very well respected by both law enforcement and the business. But let me tell you what else we did. The first thing that we discovered was that our revenue projections, as I mentioned, were too optimistic, and we were experiencing a shortfall in our cash funds. Second thing we discovered was our expenses needed to be addressed. Taking responsibility meant that beginning in the third quarter of fiscal year 2012, and I want you to know that that was long before, and that's fiscal year 11-12. Remember that. So that's the first quarter of actually the year 2012. So that was probably 9 months before that election. The department began to evaluate ways to reduce expenditures of the division and to curtail operations in the wake of a shortage of revenues being collected. It also meant that we began to look at ways to increase revenues. So what we did was we did a number of things. We also we did things to increase revenues, so we went back and figured out that for those individual businesses that had not been licensed, we could at least ask for one annual licensing fee. So we did that to start bringing in money. The other thing we did is we eliminated excess vehicle fleet, and we did that long before the audit report came out. We talked a little bit about the Franwell contract and what we did with that. And then we initiated a layoff plan. We knew that we couldn't continue to have individuals working for us because we couldn't pay them. So in May 2012, long before the audit or the election, we worked diligently to transfer out 20 employees out of the Medical Marijuana Enforcement Division. But what we did is we were able to absorb them within other areas of the Department of Revenue. And so, like I said, as a result, we've been working on a skeleton crew, 15 people since then. And that's part of the reason that we were unable to do a lot of the regulatory work and the enforcement work that we were intended to do. We were really trying to just get businesses licensed. I think someone said we were operating on it's basically a skeleton crew. But we also really started putting together some additional accounting and budgetary controls. So back in April of 2012, we put together a lot of oversight in our expenditures. Those expenditures had to come to me for approval at that point, which was pretty unheard of in all the other departments and the other divisions. And as a result, we also created a controller position. So we have done a number of things. I can go on and on and on. I have lots of pages here. But essentially what I really wanted you to understand is that, and the other thing, as I said, we moved forward with decoupling the local and state licensing process, because what that did is that really tied our hands. We could not license unless the local determined that this business was to be licensed. And as a result, we couldn't issue a conditional license, and we could not then begin to assess an annual licensing fee, which was absolutely necessary to be able to do the work that we were required to do. So we actually tried in the 2012 legislative session to decouple that, and we were not successful. So we tried again in this 2013, and this time we were successful. And we also were able to do that with the adult use as well. So what I will tell you is that because of the effort that we began soon after I came on board, and we all came on board, work was already well underway. And so I can assure you that we did not wait for the state audit for us to act. We'd been doing that for a long time, and we took a very top-to-bottom approach. We rethought every decision. We added necessary oversight. We challenged every assumption. So what I will tell you is that sitting before that audit committee, sitting before the Joint Select Committee, and sitting before the House Finance Committee was unbelievably uncomfortable for me. And there is no way that we will sit in front of those committees again next year with this very same discussion. Things will be, as I said to all of them, and I will say it to you, things will be different, and things have begun to be different, and we're already in the process of turning things around. So I can assure you that whatever happened in the past, there are a lot of lessons learned, and they've all been learned.
Good. Thank you. Any more questions to my colleagues? Barbara, thank you. Ron, thank you. Laura, thank you for coming today. We appreciate your input, and we will be watching, and you'll be watching us, I'm sure.